Okay, I am Mr. Tripod. Sorry. It's Mr. Tripodes. Tripodes, and I am defense attorney.
I am the court.
I am the witness.
I'm for the plaintiff, Mr. Ward, W-A-R-D.
Okay, and we're starting off in colloquy, going into direct examination by me, defense attorney. Ready? At this time, the defense would like to call Mr. Odie Pierce to the stand.
Because of the type of job I hold, I would be happy to testify to what I saw on the job because of my job. I would like to be excused from testifying as an expert witness.
I do not know what your job is.
I am Deputy Registrar for the Contractor State License Board,
You are a deputy what?
Senior Deputy for the State Contractors Licensing Board.
Is this witness to be called as an expert or merely called to testify to what he observed?
Primarily to testify to what he observed, and whether or not I would use him as an expert depends on sort of my feeling, my way around it. I do believe that it was only to be as an individual who has personal knowledge.
Then we do not have the problem. Please be seated and state your full name.
Odie Pierce.
How long have you been with the Contractor State Licensing Board?
I would object to the question. If we are not going to qualify that man, I do not see how that is relevant.
Overruled.
10.5 years.
And prior to that time, what did you do?
Your Honor, I object to this question on the same basis. This does not have any relevancy.
Overruled.
I was a general contractor. I have a contractor's license with the State Contractors Licensing Board.
How long were you in the business?
I obtained my last one in spring of 1990, and I was active as a general contractor until 2003 when I took my present job.
In June, in the first 6 months of 1992, you were employed by the State Contractors Licensing Board.
That is correct.
In that capacity, in that period of time,
As a senior deputy,
did you have occasion to go to the premises of Dr. and Mrs. Combs in South Pasadena?
yes, I did.
Do you recall approximately when that was?
I think my first visit to the Combs residence was June 22nd of that year.
At whose request?
Attorney Brian McKay.
And you understand him to be representing the Combs, is that correct?
That is correct.
On that date then, you did go to this address of the Combs?
Yes, I did.
Were you asked by the Combs and Mr. McKay to look at anything in particular?
Well, we made a general inspection of the complete work that Mr. Allhandy had accomplished.
At that time, had you seen any written agreement between Combs and Mr. Alhandy?
That was presented to me when I came on the job.
All right, by looking at these, let me show you these exhibits 1, 2, and 3. Can you tell us which was shown to you when you came on the job there?
It could have been either one of the two. They looked pretty much the same.
Are you referring to exhibit 1 and 2?
Yes.
Were you shown that document dated March 13, 1992, labeled exhibit 1?
I do not remember the date that is on them. I remember being shown a contract. If this is the one, I do not know.
But the items listed in Exhibit 1 and Exhibit 2, you are saying it could have been either one of those two that you saw?
That is correct.
The exact one you do not recall at this time?
Your Honor, may I address the court?
Yes.
I would request that counsel be asked to set forth an offer of proof with regards to what this gentleman will testify to. I am thinking in my mind how this testimony could be relevant. I am having difficulty. Perhaps if we had an offer of proof and the court would rule that this is going to be proper evidence in this case.
Do you have a motion?
If it is not in the form of a motion, I would move to strike the testimony of this witness so far, preclude any further testimony from this witness unless there is an offer of proof as to what counsel intends to prove by his testimony.
That motion is denied. You may proceed.
Did you then inspect the premises at that time?
Yes, I did.
Were you accompanied by any other persons at the time?
Yes.
And who were those persons?
There was Mr. Allhandy and his son and another man, I do not know his name, Mr. McKay, Dr. Combs, and there were two gentlemen from other contracting companies there.
Did you make notes of your observations on that date?
Yes, I did.
Did you bring those notes with you today?
I did not bring those notes, but I have a little list of the items that I included in my report submitted to my agency.
I wanted to ask you questions about what you saw. Would it refresh your recollection if you were to look at that note that you brought with you today?
Yes.
Can you tell us, Mr. Pierce, what was it that you observed regarding the work done by Mr. Alhandy on the Combs home?
I would object to the question on the same ground. I do not see how any testimony as to what this man observed is relevant.
I do not know what he is testifying to at this point. The objection is overruled.
Even more so than before, I can see nothing this gentleman can testify to that would be relevant to this proceeding that is admissible.
Do you want to take this witness on voir dire?
No, I don't.
Your objection is overruled. He may testify.
Can you tell us what you observed on that date with respect to that home?
Yes, I can. The group started at the front of the house on the parkway. The first item that was observed was a block wall. The block wall they were the same size block, but were not of the same type as the original wall, and the lines of the block were not straight. The parkway itself, specifications called for topsoil to be placed in this area, and there was a bunch of wood chips that appeared to have come from the dumpings of a tree chipping machine approximately from the city someplace.
Your Honor, I would object to the answer that has been stated so far and move to strike.
I am not going to rule on anything other than a question-by-question objection and answer. If you have an objection to the statements, it should be made with reference to the parkway.
I object, move the answer be stricken with the block wall testimony in regards to his opinion as to what it is, referring to this letter as to what was done in that regard.
The objection is overruled. The testimony about the block wall, the blocks not being of the same type, the objection as to that portion that followed it is sustained as calling for speculation and a conclusion, and the answer that somebody came in, dropped topsoil or chips,
That is only part of the answer.
that is the part that will be stricken.
Perhaps counsel can ask the question as to what he observed. I would like to see the notes.
Mr. Pierce, perhaps as you reach each item, if you would mention the item observed first and then describe what you saw. Could you go to the next item?
The next item refers to exterior painting.
Now tell us what you observed with respect to exterior painting.
I would object to any testimony with regards to the observations as to the exterior paintings. His testimony with regards to the exterior painting would be conclusionary unless he actually knew.
The objection is overruled. You may answer the question.
The exterior painting was observed, and on the south side of the building, some skips or voids were noticed, and the paint was very thin. The next area,
Still talking about painting?
yes, on the front porch, this was also observed.
Now this is with respect to the painting, is that correct?
Yes, and the next item also deals with exterior paint. The shutters were not properly repaired and not painted on the back side.
I object to the term not properly repaired.
Sustained. That will be stricken.
The paint on those shutters, they were painted on which side?
I said they were not painted on the back side.
How many shutters did you observe that were not painted on the back side?
I didn't see any of the shutters that were painted on the back side. None of the buildings were painted as far as I know.
Did you observe all of the shingles on the house?
Yes.
Were you advised by any party as to what was repaired?
Yes.
Which person explained the work that was to be repaired?
Attorney McKay.
Did anybody else indicate what work was going to be done?
I don't think so.
Who was present when Mr. McKay told you?
The whole group was present.
Was Mr. Alhandy present?
Yes.
Did Mr. Alhandy explain any opinion as to whether the work was right or wrong?
Mr. Alhandy did not offer any explanation to me or to the owner of the house. He observed and went along, and that was it.
Did Mr. McKay tell you the repair work that was supposed to be done?
Objection calls for hearsay.
I will have to sustain the objection.
Mr. Pierce, do you have any other information regarding the exterior paint?
The exterior paint? No.
Can you tell us what is the next item?
The plastering on the front porch, it was explained to me.
We are now at the point of hearsay testimony.
If you just tell us, Mr. Pierce, what you observed with respect to the place rather than tell us what somebody told you.
Here again, he does not know what to look for unless he is told to look out for certain things. The response is suggested by the attorney asking the question.
There is not a scintilla of evidence so that anybody has suggested an answer. It seems to me that certainly in the posture of the question that is pending there is nothing objectionable. We are talking about the front porch, plastering at the ceiling, and regardless of what anybody said to you, did you look at it?
I observed the ceiling of the front porch.
What did you see?
That it had been repaired, new plaster in one area, and the ceiling had been painted.
Did you observe anything unusual with respect to the painting that you saw?
The painting did not cover properly.
Could you explain what you mean by did not cover?
It was not even in color throughout. It did not cover properly.
Then the paint did not cover the whole ceiling.
It covered the whole ceiling.
With respect to the plastering of that front porch, did you observe anything unusual?
No, nothing unusual.
Can you go to the next item?
Then we go inside of the house and then we notice that
I object, Your Honor. I think we have dealt with the subject matter before.
Are we talking about the exterior or the inside?
we are talking about inside
With respect to the trim or what?
repairs, the way it was to put to,
You went into the dinette area.
yes,
Counsel, let me stop you. It seems to me that the first thing that you should do when you put on a witness is to confer with that witness so that we can avoid all of these objections. I'm going to give you an opportunity at this time to talk to your witness. We are going to take a recess in this case until such time as you are ready to proceed with the witness and know what he is going to say. We will go from there. This matter is in recess. In the matter of Alhandy versus Combs, you may proceed, Counselor.
I do not have any further questions of this witness on direct examination, Your Honor.
You may proceed to cross-examine.
Have you ever seen this house before this walkthrough on June 22nd, 1992?
no,
With regard to this block wall, you say the blocks used in repairing the wall were the same size and not the same type as the original wall.
yes.
Please tell the court the type used in the original wall.
I do not know the type of block that was used in the original wall. All I know is that the two blocks were not of the same manufacturer and did not match.
Do you know when that block wall was originally built, Mr. Pierce?
I would have no idea.
Do you know whether the blocks used to construct that block wall are still manufactured or available on the open market?
I would not.
Do you know how much of that block wall had been damaged or knocked down, thereby necessitating the repair?
I can tell you about how much there was replaced by the one-type block.
How much?
I would say probably 20 feet long, probably 2 feet, 2.5 feet wide, high.
In other words, approximately 20 feet of this block wall had been knocked down or something had happened to it, causing the need for repair. Is that correct?
The top 2 feet, I would say, or a little better than 2 feet.
I thought you said 20 feet.
The top 2 feet for approximately 20 feet in all.
Let us try again.
2 feet off the top of the wall for a distance of 20 feet.
Very well. Do you know whether or not Mr. Alhandy or someone working for Mr. Alhandy, and I will say Mr. Alhandy, any of his subcontractors or employees, do you know if they painted the south side of this house?
No, I do not.
So you do not know if these voids and skips that you made reference to were even made by Mr. Alhandy, is that correct?
Not to my personal knowledge, no.
When you inspected this house, you inspected the entire south wall, is that correct?
I inspected the whole house.
Just concerned about the south wall, sir.
All right, tell me who you are.
Okay, and for the defense, Mr. Wing, W-I-N-G.
I am the court.
I am the witness.
I am plaintiff's attorney, Mr. Morrison, Morrison. Okay, it starts with me. Question by plaintiff's attorney. Ready? Is that when the arguments would start, when you would come home from the bar?
No, not always when I came home from the bar.
Is that when she would argue about the drinking?
Not all the time.
What other times did she argue about your drinking?
Later on that night, sometimes she was up at 10, and when she felt like arguing or complaining about it, it would be then.
Well, do you think she had legitimate complaints about your drinking?
Sometimes, yes.
Okay, so at least sometimes you brought the arguments on yourself through your conduct, is that right?
Yes, a few times I would say I did.
Well, was it usually her fault, the arguments?
I don't know.
Well, was it usually your fault?
I don't know that either.
So you don't know whose fault the arguments were?
I don't know which arguments you're talking about.
Well, I wasn't there. I'm just trying to understand whether she was making legitimate complaints.
Objection, Your Honor. It's too vague. I ask that counsel be more specific.
Yes.
That wasn't the question. It was kind of a preamble to a question.
Yes, all right.
When she argued about drinking, when she complained about that, you said sometimes that was at least a legitimate complaint?
Yes.
How about the financial matters? Was that sometimes legitimate?
Not very often.
Okay, well, why not?
Well, because I don't know how to put it. Most of the time she caused her own financial problems.
Well, did she spend lavish amounts of money?
She had enough money to do what she had to do.
When you moved up to Humboldt County the first time, did you start drinking at the Red Lion?
The first time?
Yes.
Yes, I went in there when I first came here.
Was it a daily routine to go in and have a couple beers or 2 or 3 beers and then to begin drinking whiskey and 7-Up. Is that right?
Not every day, no.
How often?
The first time, maybe a couple times a week. I had other things to do, and I would go in and have a couple drinks and then go out. I didn't stay that long.
You went in a couple times the first weekend. You would come and go and run errands. Is that what you're saying?
Yes.
What were the errands that you were running?
I was looking for La Vida.
Okay. Did you call her mother while you were up here and ask her where La Vida was?
Up here? I don't believe I did. I don't remember.
When La Vida left Los Angeles, did you check around among her friends to find out where she had gone?
I believe I did.
Okay, and who did you contact?
I talked to Bonnie Lane.
But what was your tone of voice when you spoke with Bonnie Lane?
Objection, Your Honor, irrelevant. It's beyond the scope.
I think it's relevant, Your Honor. His attitude in looking for his wife was...
Well, I'm sure he wasn't happy about it. It's irrelevant.
I'll sustain the objection.
Your Honor, can we approach the bench so I can be heard on the matter?
All right, I would prefer that you would have asked in advance.
I'm sorry.
Excuse us, ladies and gentlemen. Yes?
I apologize for the method.
That's all right.
Now, the point that I want to make is that while he was looking for his wife, he was not grieving over his loss, but instead was angry with her, and I think that anger is consistent with killing her. The testimony would be that he was angry and threatening when he was looking for her.
Well, you know, I was wondering why counsel doesn't ask her if he was angry about her leaving. I'm sure he'll be honest, and I think that he will testify that he was upset about it. I think counsel is getting